Welcome to the College of Labor and Employment Lawyers, the Maryland Employment Lawyers, and the Metropolitan Washington Employment Lawyers Association's October webinar, Severance Agreements, How the NLRB Has Changed the Rules. I'm Scott Oswald. I am MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, Yona, Rozen, and Ashley Bosché from the College of Labor and Employment Lawyers and the Maryland Employment Lawyers Association are here to tell us a little bit about their organizations. First, Yona Rozen. Yona?
Thank you, Scott. As Scott said, I'm here in my capacity as a board member of the College of Labor and Employment Lawyers, which is an organization that was started in 1995, the 60th anniversary of the National Labor Relations Board and the 30th anniversary of the Equal Employment Opportunities Commission, with the idea of having a organization that stresses excellence, integrity, and leadership amongst labor and employment lawyers. And it is an organization that does both regional programming, national programming, social activities, and is open to lawyers who have practiced in the field, lawyers who have demonstrated their excellence and have practiced in the field of labor and employment law for 20 years. That 3 of those 20 years can be clerkship, but otherwise the rest of the 20 years has to be at least 50% of your practice. It can be in any of the constituencies. So in my real life, I am a union side lawyer, but the beauty of the College of Labor and Employment Lawyers is that I have contact with lawyers who are in management, lawyers who are representing employees, lawyers who are in government, lawyers who are neutrals, arbitrators. And it is a wonderful organization in terms of really stressing the collegiality and ethical practices in the practice of labor and employment law and excellence and leadership in that field. So on behalf of the College of Labor and Employment Lawyers, I welcome all of you to this program. And thank you, Scott.
Oh, you're welcome, Yona. Thank you. And now to Ashley Bosché. Ashley?
So I, too, am on a board. It's MWELA, and MWELA is the Maryland affiliate of the National Employment Lawyers Association, which is an organization comprised of attorneys who primarily represent employees in labor and employment matters. It is limited to attorneys who dedicate 60% or more of their practice to representing people and not companies. So it's plaintiff represented. We hold social and CLE events throughout the year. We're actually working on our next event, which we will post on our website. If you're interested in joining or getting information about that event, our website is posted here. It is marylandemploymentlawyers.org. I want to thank MWELA for the opportunity to speak about our organization and to attend, and I'm very excited to hear our speakers today.
Ashley, thank you. Now to our participants in today's roundtable. First, the Honorable Benson Legg is the former Chief Judge of the United States District Court for the District of Maryland. As a mediator for JAMS, Judge Legg brings deep experience to his full-time ADR practice. The Honorable William Connelly is a former Chief Magistrate Judge for the District of Maryland. And during his time on the bench, Judge Connelly presided over more than 1,800 settlement conferences. As a mediator for JAMS, Judge Connelly has conducted more than 380 mediations. Jessica Childress is the managing attorney and founder of the Childress firm. Jessica primarily represents employees in employment disputes. Janea Hawkins is an assistant general counsel for employment law at Freddie Mac. Prior to this role, Janea worked as an associate attorney with the law firm of Jackson Lewis. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer from Jessica Childress on how the NLRB and other agencies are changing the rules of severance agreements. Jessica, start us off.
Thank you so much, Scott. Good afternoon, everyone. It's truly a privilege to be with you this afternoon discussing a topic that several practitioners have really been thinking about and have questions about, And that is, what does the McLaren-McComb decision say for the future of severance agreements and other employment documents? So Ed Scott mentioned, I'm going to give you a primer of the McLaren-McComb decision and also what other federal agencies have been saying about commonly proffered provisions in employment documents, including severance agreements. So first, what is Section 7 of the National Labor Relations Act? Well, Section 7 of the National Labor Relations Act truly is at the core of the McLaren-McComb decision. And just breaking this provision down, breaking this section down to its core, Section 7 gives employees the right to organize, bargain collectively, and most relevant to our discussion today, this section gives employees the ability to engage in other concerted activity. These rights apply to employees whether or not they are unionized. Now, Section 7, or the National Labor Relations Act in general, applies to non-supervisory, non-managerial employees. We'll discuss what that means briefly with respect to the McLaren-McComb decision and whether supervisors have any protection under the National Labor Relations Act in just a moment. But Section 7, most importantly to our discussion today, gives employees the rights to engage in other concerted activity. So what is Section 8A1 of the National Labor Relations Act? This section, it prohibits employers from interfering, restraining, or coercing an employee in the exercise of the rights guaranteed under Section 7. So this is really the enforcement arm of the National Labor Relations Act. This is the provision that requires that employers respect an employee's Section 7 rights. Now, why you're here today, we want to know, what does McLaren-McComb mean for severance provisions or severance agreements in general? Are they allowed? Are they still allowed? Are confidentiality provisions still allowed? Or non-disclosure provisions still allowed? There were a slew of questions that came through on the MWELA listserv when this provision or when this decision first came out. So I'm really excited to engage in this discussion today. But there were two provisions that were at issue in McLaren-McComb. One was a non-disclosure provision, one was a confidentiality provision, and the language of those provisions is on your screen today. Now, if you've been practicing for any amount of time, if you've ever negotiated a non-disparagement or if you've ever negotiated a severance agreement, even an employment agreement, these were extremely typical, extremely common provisions. They really were never under scrutiny the way that they are today. But the National Labor Relations Board issued this groundbreaking decision on February 21st, 2023, finding that these provisions were unlawful. There were several questions that came out of the field regarding what this actually meant for the future of severance agreements. I know myself, I had several questions as to whether severance agreements were still allowed. So thankfully, the General Counsel of the National Labor Relations Board, Jennifer Abruzzo, issued a clarifying memo in March of 2023. General Counsel Abruzzo's memo clarified several questions that were coming from the field regarding what did McLaren-McComb mean? Are severance agreements still allowed? Are confidentiality provisions still allowed? And General Counsel Abruzzo also left some tea leaves on the ground about other potentially problematic provisions in employment agreements. But Secretary Abruzzo said that confidentiality and non-disparagement clauses are not prohibited and can be lawfully drafted, and this is the key, so long as they are narrowly tailored to restrict the dissemination of proprietary or trade secret information for a period of time based on legitimate business justifications. So that was a pretty packed definition. But the takeaway is that they are allowed, confidentiality and non-disparagement clauses are allowed, but they have to be extremely narrowly drafted And they even have to comport with this trade secret protection. So if you're a trade secret practitioner, you understand that that's a term of art, and there's lots of litigation surrounding what actually constitutes a trade secret. The General Counsel's memo also noted that for non-disparagement clauses, they have to actually meet the definition of defamation. They're only allowed if the employee's comments are defamatory. So again, that is another area of law that it's a term of art. It's a highly litigated area of law. So there are still questions surrounding the scope of lawful confidentiality and lawful non-disparagement provisions. But essentially, this memo showed us that these provisions are certainly on the chopping block, and there is a ton of risk to include them if you're an employer in a severance agreement. The memo also clarified that McLaren-Macomb does apply retroactively, and the National Labor Relations Act has a 6-month statute of limitation. Moreover, the memo clarified that an employee cannot waive these rights. And in our discussion, we'll go into what that means for severance negotiations. But these are rights that cannot be waived. To whom does this decision apply? The National Labor Relations Act applies to non-managerial employees. McLaren-Macomb did not change that. The National Labor Relations Act has always applied to non-managerial employees. So this decision is not applicable to supervisors or managerial employees. Non-disparagement agreements, provisions, confidentiality provisions can still be provided and proffered to managerial and supervisory employees. However, the General Counsel's memo did clarify that the National Labor Relations Act may protect supervisory employees who are retaliated against for refusing to violate the National Labor Relations Act. And we'll go into some examples of what that might look like in a practical setting. The National Labor Relations Act only applies to private sector employees. So the question has arisen, does McLaren-Macomb apply to other employment documents, such as handbooks, settlement agreements, non-competition agreements, and other restrictive covenants? Well, the tea leaves that were left indicate that yes, McLaren-Macomb will in fact prohibit these unlawful provisions, these unlawful confidentiality provisions, unlawful non-disparagement provisions in other documents, not just severance agreements. A question that has arisen from some MWELA members, does this apply to settlement agreements? And the General Counsel's memo noted settlement agreements. And settlement agreements should essentially be only a release of claims. They should not prohibit the terms of the agreement itself. And so this has a far-reaching effect, unlawful, overly broad confidentiality, overly broad non-disparagement agreements in documents that are not simply severance agreements are likely going to be found to be unlawful. And in just a few slides, I'll talk about the future of non-competition agreements. But the General Counsel has been very clear that those agreements are also subject to immense scrutiny. She does not like them, essentially, and believes that they chill employee speech. And in fact, that memo that she issued regarding non-competition agreements, it's not law, but it certainly gives us an indication of where the National Labor Relations Board is going with respect to non-competition agreements. And we'll talk about what other federal agencies how they have viewed such agreements in just a moment. So what happens if there's actually a violation of the National Labor Relations Act? Well, there's no private right of action for a violation of the National Labor Relations Act. The prosecutorial body for the National Labor Relations Board is the General Counsel's office. So they would file a claim, they would seek injunctive relief, they can ask the employer to rescind the unlawful agreements, but there is no private right of action or right to attorney's fees under the National Labor Relations Act. is the National Labor Relations Board doing anything regarding, are they actually enforcing this, or enforcing violations and bringing claims for violations of unlawful provisions that extend beyond severance agreements? And the answer is yes, they absolutely are. On September 1st, 2023, the National Labor Relations Regional Office in Cincinnati filed a complaint against the medical spa over unlawful provisions in their employment documents that did not include severance agreements. It did not include solely severance agreements. There were several unlawful confidentiality, non-disparagement, non-solicitation, and training repayment provisions, which is something that the National Labor Relations Board never discussed, repaying for training in the event of a violation of a non-compete agreement. But the SPA required two employees to repay the company for the training fees that the company had expended based on the employee's violation of a non-compete. And the National Labor Relations Board sued the SPA, saying that that was an unlawful violation of Section 7 of the National Labor Relations Act. That case is still pending, so this is certainly one to watch. But what this case shows is that the National Labor Relations Board is going to be very aggressive and very active in scrutinizing agreements and documents that they find to violate or chill an employee's exercise of their Section 7 rights. As a remedy, in this case, the National Labor Relations Board is asking that the company rescind the unlawful provisions in its employment documents, make the aggrieved employee, there were two employees, but make one of them whole for any consequential damages as a result of the employee's discharge, pay the aggrieved employee the value of the employee's PTO, and then rescind the unlawful demands that the respondent pay two of the employees, requiring them to repay the respondent for training. So what are other federal agencies doing with respect to these unlawful or potentially unlawful provisions? What is the future of confidentiality agreements, something that so many of us put our hands on, negotiate every day? Well, the SEC has brought an action against D.E. Shaw and Company, LP, for unlawful confidentiality provisions in September last month. And D.E. Shaw agreed to settle the case for $10 million. So these are expensive cases. And the problematic provision in the D.E. Shaw case was that there was no carve out to allow employees to speak to the SEC. Now, the SEC has long scrutinized confidentiality agreements that do not have a carve out. But you can see that the SEC is not resting on its laurels. It's actually coming after companies for the proffer and the maintenance of these agreements. So it's extremely risky for an employer to maintain unlawful provisions that include these overly broad confidentiality agreements that have no carve out to discuss the terms and conditions of the workplace with government agencies. The FTC has also been has scrutinized non-competes, and there is a proposed ban, a proposed rule that actually closed for public comment in April. But the proposed rule would completely ban non-competes. So we will see next year if a final rule is promulgated, but confidentiality agreements, non-competition agreements, provisions that we are very, very accustomed to negotiating and looking at in drafting, they very much could be on the chopping block. And so this conversation next year could be very, very different with much more certainty. So I will turn the conversation over to Scott and my esteemed panelists so that we can engage in further discussion.
Jessica, thank you.
You're welcome.
Janea, I'd like to kind of begin our discussion with you from the point of view of management perspective and the decision's impact on the settlement process. So has the NLRB's McLaren-McComb decision affected how you as an institutional employer council view post-employment restrictive covenants? How's it affected from your perspective?
Yes, and Scott, thank you for that question, and also thank you for having me on this panel of such esteemed panelists, and happy Friday Eve to everyone. So to answer your question, Scott, I would say that in wake of the McLaren-McComb decision, of course, employers generally, and as they should, are reviewing everything. Everything is going under a highly scrutinized lens. So we're looking at language in employee handbooks, we're looking at policies, we're looking at communication to the workforce. We're looking at, of course, settlement agreements, severance documents, because we don't want anything to even give the appearance that it's running afoul of the not only the decision but also of employee Section 7 rights. So to General Counsel Jennifer Abruzzo's memo, as far as a lot of the things that she, as Jessica mentioned in her primer, a lot of the types of clauses that we so commonly used before, we're now looking at with a closer lens, because one, we have to ask, what are we solving for? What is it that we're trying to fight for in having this provision? Is it worth the fight having here? Also, looking at it to be as narrowly tailored and as specific as possible. Anything with respect to duration of time, looking at that, looking at the broad reach of the provision, and is there a way to make sure it's narrowly tailored to meet the very specific legitimate business need? So I would say any of those provisions that you would see that could even possibly run afoul of Section 7, they're under a heightened scrutiny and a closer lens now.
So although McLaren-McComb doesn't apply to employees who are managers, has the decision affected when you use non-disclosure confidentiality agreements with managers?
Well, I will say again, it's a very case-by-case basis whenever you're looking at managers of an employer, because sometimes there may be particular interests with that particular employee. Sometimes, like when I was at outside counsel, I would work with different sizes of corporations, different types of industries, and sometimes depending on the position of the person that they were trying to reach agreement with, they might have had specific considerations with that particular person. What area of the business did they work in? How many reported to them? How high up in the organization were they? Were they an executive, or were they a manager or director? What kind of access they had to information that the organization would want to protect. So it's really very much a case-by-case basis to determine whether or not they find it necessary to really fight for a provision, or maybe they would go on the be a little more risk averse, and then kind of go on the less stringent side of the spectrum.
Are you worried at all about confidentiality and non-disclosure clauses that you already have in place with either existing employees or former employees?
I would say generally from a standpoint, I mean, you never want to rest on your laurels. You always want to make sure that you're reviewing for whatever's compliant with the law. So I would say not so much worried, but just being conscientious of how the law is forever changing and keeping a close eye on developments, looking for specific rulings that will give guidance as to specifically what provisions will hold up, what provisions don't hold up. So it's a constant evaluation process.
Okay. So you mentioned that you're looking at these kinds of clauses across the board within Freddie Mac as an example. Just step us through some of the questions, right, that you're asking in, let's say, various sets of documents where these kinds of provisions might lie. What are the kind of questions that you're asking managers who've entered into, officials that have entered into these kinds of agreements?
One of the primary questions that we'll ask are, well, what is the goal here and what are we solving for? What is it that if it's confidential information, if it is trade secrets, as Jessica mentioned in her primer, which is a constant evolving definition, and what's a trade secret? If it's proprietary information, what concerns do you have? And what are the best ways to kind of address those concerns? What kind of language will help meet the goals that you're trying to reach? I would also say that one of the questions that we'll have and that always come up is when it comes to communications and the advent of social media, which has made things a whole new ballgame. It used to be a fear of maybe a phone conversation or speaking something publicly around friends, but now it's a heightened stage, right? When you have these different social media platforms, such as your Glassdoor, your Fishbowl, your Facebook, your Twitter, your, name it, insert the platform. So I would say sometimes questions around that, sometimes with particular employees, some of them have a social media presence about their employer currently, and some never discuss their employer and their social media. So sometimes it's kind of looking at that particular employee and really figuring out how can we tailor this as narrowly possible as needed for the legitimate business interest.
Are you auditing Freddie Mac's onboarding documents for potentially violative provisions that they might contain?
Onboarding is definitely part of the package. Any communication, agreements, documents that we are entering agreements with employees, asking them to sign and assent to terms, it's going to be part of the review, absolutely.
Judge Connelly, I'd like to turn to you and talk about the mediation of employment claims. Tell us how you curate with the parties in the mediation process the importance of non-monetary terms to one side or the other in the run-up to the actual mediation itself.
It's my practice to have individual calls with counsel prior to the mediation, and these usually take place a day or so before the mediation after I've had the opportunity to read all the papers. We go over a number of items, but one of the items I always ask counsel is there any non-economic relief that you are seeking? What is it? Do you feel that this is going to have pushback from the other side? And so I assemble that. I do about 20% of my work is employment litigation. And many of the cases are not, in essence, covered by this particular case because they are management or supervisors, or they may be operating in the public sector. For those that are, I will usually raise this. I'll say, there's been this case from the National Labor Relations Board back at the end of February, and it has given out some new law, and I'm certain that you're aware of this. And the response I get is, I get a few people that say, yes, I'm quite aware of it. And I get some that the response is not as reassuring as I had hoped. So I will generally tell them the name of the case as well as the date, the issuing authority, and then sort of summarize I think the holdings that are applicable here. Give them time to read up on it. As the mediator, your big job tends to be getting to the number. And after you get to the number, many other things fall into place. You're also normally not involved in the actual drafting of the agreement. And probably only in about 5% of the cases do I get called back in after the mediation's over, either because there's a delay in getting the agreement done and people want to get paid and over with, or there may be language difficulties at which they'll ask me to come back in and try to help. I try to, during the mediation, if there is going to be issues, because I will always, usually about a third of the way into the mediation, start raising the non-economic concerns, since I don't want to wait until the end. And if I get pushback, I'm in the mode of talking to both sides, trying to find out what they are in essence attempting to settle or protect. And sometimes it's fairly discreet. It may be one or two contracts that are coming up for renewal, really certain, and it's the information applicable to them. And so frequently you can get some agreement between counsel and the parties as being the facilitator in the case. There are times that surprising things happen. People normally think it is the employer that wants to keep the amount of consideration quiet. But I've had a number of cases where it's the defendant that wants that simply because they're coming into a significant amount of money and they would prefer not to have friends and relatives and the like to know that. Gives them an easy out to say, I'm sorry, I cannot tell them that. But I agree with the prior speakers who have spoken well on this, that it's an issue of defining down or closing and making it as narrow as possible, because you want to be able to explain, if it's ever questioned, why it was so important from a business standpoint that this be done, and why it does not interfere with the Section 7 rights of people covered by the National Laborers Act.
Judge Connelly, thank you. Judge Legg, let's turn to some of the common barriers to settlement in an employment dispute. What are those common barriers that counsel for each side should consider in advance?
Good. Thank you, Scott. Back in the when I started practicing law as a private attorney back in the Pleistocene era, the law was simpler and settling cases was simpler. If you had an employment discrimination case, if it was settled, there would simply be a dismissal of the lawsuit with prejudice, a few lines, and that's it. Over time, based primarily upon the ingenuity of defense counsel, one saw the intrusion of a plethora of clauses, such as the confidentiality clause. You can't tell anybody about the settlement. Non-disparagement. You can't say nasty things about your former employer. Liquidated damages in the event that there was a violation of confidentiality or non-disparagement. A no rehire clause. The extension of the no rehire clause to any affiliate of the corporation. Often a plaintiff might want purging of a disciplinary record or a positive reference. If the defendant is a company in, let's say, the defense industry where there are lots of government investigations, where there's a government investigation in the offing, the company may want the former employee to agree to cooperate with the company in any governmental investigation, sometimes without a statement of what that would entail. And also, it always seemed to me that if the employee is cooperating with the government investigation involving a matter in which the employee was involved, that employee may need counsel, so that because the employee may have some liability. Then there are arbitration clauses and venue clauses, so that the defense counsel puts in a clause that if you have, disparaged us, we want to have mandatory arbitration that will be venued in North Dakota, let's say. And covenants not to sue that go beyond the employment relationship. So you may have some other type of claim that the employer wants to terminate. So we have now seen in the McLaren-McComb decision that there was a focus on two types of outlawed provisions: non-disparagement clauses and then non-disclosure clauses. So we see that the general counsel really took upon a huge burden, because in time, the general counsel is going to have to weigh in on all of these other types of clauses. And we see that the general counsel had to come up with and publish a follow-up that talked about other types of clauses. So this is really a cottage industry, and we see that our esteemed counsel are going to have to go back perhaps and look through all of these past employment agreements to see whether they are violative of the Title VII or Article 7. So as Bill said, in a mediation, one wants to smoke out the clauses that really should be in play before the mediation begins, so it doesn't become a roadblock at the end of the mediation. But on the other hand, as Bill also said, the primary issue in the mediation is the money. How much, when it's going to be paid, and a lot of these other issues really don't crop up. So I've found that I've never had a mediation that was derailed after the money was decided upon, because both sides tend to just want to get the thing over with, particularly because, all of our panelists know, sometimes the mediation isn't concluded until 2:00 in the morning, and everybody just wants to, go home, go to bed, and have this put in the rearview mirror. So the basic takeaway is there are lots of clauses that people might want. Find out about them before the mediation begins. Be prepared to come back into the mediation maybe a week or two after the case has been resolved, because you always want to offer to help smooth over any rough spots in the documents. And finally, it's always helpful for one side or the other, usually the defendant wants to do it, to offer to write the settlement documents and then distribute them to the other side. So that's a good thing to do.
Judge Legg, thank you. Janea, I'd like to bring you back in at this point and talk a little bit about your viewpoint when you were outside counsel. So this is where you're advising the company from the outside. Mm-hmm. Were there situations where senior management would come back to you and say, look, we care deeply about the language of non-disclosure in a settlement agreement?
Mm-hmm. Yes. There would be times, again, you looking at the relationship between employers and their employees, right? All employer-employee relationships are not created equal. And a lot of times when we would be talking about exiting the employee, they weren't getting along. Sometimes it was, we're trying to make this as amicable for everybody involved. But by the time towards the end, they're just like, we just want out. And if we're going to get out and we're going to write this check, we need these terms attached to it. So there would be times, particularly with somebody who was much higher up in the organization, if they were a senior member of the senior committee, if they were an executive or what have you, and you're working with the management representatives, so you're working with their peers. These are people who sometimes have worked together side by side for a long time. These are people who know each other very well or thought they knew each other. And by the time towards the end of the relationship, they found out they didn't know each other as well as they had thought. So all of that plays into what terms and clauses are going to be incredibly important for the employer. So you kind of start when you're at the drawing board, you might just draft what was, your standard agreement or standard language that you might use, from a firm template or what have you, or agreements that you've used in the past. And you say, oh, I think this one applies here. And then you make tweaks based on the situation. You make tweaks and you figure out what you want to put forth or proffer for that particular agreement. And the employer, our client, sometimes would come back and say, oh, no, we need to ensure fidelity to this agreement. And we don't trust that this particular employee or this soon to be former employee is going to honor that. So we need to make sure we come up with very stringent language on this provision or this provision. And so we would look at that. And of course, we would ask questions and we would figure out the best way to reach the goals. And sometimes we would say, hey, look, we're going to do the best we can. But if we are bound, if this is going to be unlawful down the line, you're going to be litigating this down the road, it's going to create more problems than it's going to solve for you. So a lot of times it was a back and forth communication of basically, I hear you, I understand this is what you're trying to do, but we also have obligations to draft in accordance with the law. And we want to make sure that you have an agreement that passes muster. So sometimes it would be, sometimes negotiations on terms terms and agreements could go for weeks. Sometimes they were not a quick, day or two thing. Sometimes negotiations and the non-monetary terms would be very important. And so sometimes we had to push back. Sometimes we were able to kind of go with the standard language. And again, I'll probably sound like a broken record by the end of today's webinar, but it really is a case-by-case inquiry that you really have to pay close attention to.
Well, let's talk about some examples, because you mentioned the fact that if senior management were involved, that might be a reason for a non-disclosure or confidentiality provision, that kind of caring deeply about that kind of provision. How about in a situation where there were allegations of sexual harassment?
Yeah, when you're dealing with allegations of sexual harassment, that of course receives heightened treatment for obvious reasons. It's a very serious allegation, and whether proven or not, it's something that can cause great risk for an organization. You're talking about reputational harm. You're talking about potential risk for claims, additional claims coming forward. You're talking about potential patterns, kind of lifting up the lids and seeing something that maybe you weren't aware of. So there's a whole bunch of risk kind of in that bucket. And so when you're looking at provisions with respect to sexual harassment allegations, and if you're like looking at an agreement and you're talking about exiting the employee, you are definitely going to care a lot more about non-disclosure, confidentiality, because on both sides, not only is it from the company standpoint, but usually the employee as well. They want to protect their ability to gain employment again. They have a reputation that they're trying to protect as well. And they don't want the fact that they're reaching an agreement being an admission of any fault or any guilt. And so that is when you are going to look very closely at the provisions, again, narrowly tailoring it, but also coming up with language that both sides feel protected adequately in the agreement.
How about where the allegations are against senior management, maybe misusing funds or engaging in fraud?
Again, I'm sorry. Again, no, that's definitely a very heightened thing also, because there's regulatory concerns, there are reporting concerns, like for instance, in organizations that have a duty to, when they're reporting their filings, things that they have to report. And so you have to carve out, you're considering different exceptions there, where it comes, especially for confidentiality, it's saying, well, confidential, but if obligation under law arises where we have to divulge if there was in fact a fraud or misuse of funds or what have you, that's something that's going to be a heightened consideration, because again, you have to comply with the law and in your obligations there too. So it might change again, kind of like different depending on the allegations and depending on the circumstances. It can change what provisions are going to be more important to you and what you're really going to fight for.
Janea, thank you. Jessica, I want to bring you in at this point. The NLRB General Counsel takes the position that broad confidentiality and non-disparagement clauses are unlawful even if the employee is the one that requests the confidentiality. Are there situations where an employee might be the party that really does want the agreement to be confidential?
Absolutely, Scott. And Judge Connelly, I believe, touched on this. Maybe there may be a family member who to whom the employee does not want to disclose that they've received a settlement. When people are exiting their jobs, that is a life-changing circumstance for an employee, and they may not want anyone to know that they've exited a job, because the situations in which we find ourselves representing employees, there are often situations in which the employee has undergone a transformative, traumatic experience at work. And so there are several reasons why an employee would not want to disclose, number one, that they've left a job, the circumstances under which they left a job, and number three, the money that they have received in exchange for waiving claims against or releasing claims against the company. So there are several reasons why an employee would want confidentiality regarding the circumstances under which they left the company. And there are also several reasons why an employee would want a non-disparagement provision. And I believe we'll talk about this as we go forward in the conversation. But an employee may be very concerned about a previous employer disparaging them and limiting their ability to get another job, disparaging them within the company and tarnishing the reputation that they had while at the company or the organization. And so there are many, many reasons why an employee would request a mutual non-disparagement provision in any severance agreements. But as General Counsel Abruzzo has noted in her memo, even if the employee does request the confidentiality provision, the non-disparagement provision, that does not make an otherwise unlawful agreement now lawful. So our hands can be a bit tied now, or they are a bit tied now. And I'd love to hear Judge Connelly and Judge Legg's perspective about what employees that they're seeing before them, what they're saying about some of these non-economic prohibitions that are in place now.
Well, in light of that, right, in light of what you just said, could the McLaren-McComb decision potentially complicate the settlement of certain types of claims?
Absolutely, because non-economic damages are often emotional, and every case is very different. But when you are trying to get out of a workplace, when an employee is trying to leave a workplace and start a new life, a new career, there are several reasons why they would want the non-economic damages, the non-disparagement provisions, the favorable references, the confidentiality. So there are but so many things that an attorney can ask for in a negotiation. So taking away some of the potentially lower hanging fruit, sometimes it's not lower hanging fruit, as Janea has commented on, sometimes it does take months to negotiate the non-economic damages. Sometimes the money is the easy part, and the non-disparagement is more complicated because employers are often reticent to agree to non-disparagement provisions because they are limited in what they can actually prohibit other employees from saying. So that sometimes can be a contentious provision to negotiate in general. But when this decision has in fact tied our hands a bit as to what we can ask for in a negotiation, when what the world of what we can negotiate is not in fact unlimited.
So Janea, if in the wake of McLaren-McComb, if a company can't bind the employee to keep the employee's allegations confidential, can the value of an early settlement agreement to the employer actually go down?
I'm sorry, can you repeat the question? I just want to make sure I understood it. Thank you.
So if you don't get your confidentiality and non-disclosure, could the value of the settlement to your management, because they can't get it, actually go down?
Well, that's a very good question because, again, I hate to give the lawyer answer, but it depends, because one of the important things with settlement is the release of claims, right? And the release that come along with it. So you really are going to be trying to do a cost benefits analysis. But you also very well, because especially in light of the decision, as Jessica mentioned, with your hands being tied in many respects on both sides, you may not ever get it. And so the question is then, for a settlement, from a settlement perspective, the question is, you're weighing, do we get ahead of this so that we can move on and move on to other things, even if we can't necessarily get all the bells and whistles, all the provisions that we would want? Or do we want to fight this to the death and just, take it and go as long as it takes? And that's really kind of the conversation that you have at the outset all the time. You're looking at the facts, you're looking at the likelihood of settlement, you're looking at the value and what is most valuable to you as you are trying to reach resolution of those particular claims. So it really can depend.
Judge Legg?
Just in thinking about sexual harassment claims, there are a couple of points that I'd like to follow up on. The first is that it appears that an exception to the no defamatory statements, or the ban on criticism, would not apply to defamatory statements. So that, let's assume you have so think about how that might play out in terms of an allegation of sexual harassment against, let's say, a supervisor. The first thing is that if there's no confidentiality agreement, then the supervisor may be in a position where, look, if the company settles the case, this person who I did not sexually harass will be able for, years on end to blacken my name by post on social media and otherwise that I was a sexual harasser. So I demand that we go to trial so that I can protect and clear my name, so that phenomenon can torpedo a settlement that might otherwise take place. The second is that how is the confidentiality agreement that can apply to defamatory statements, how is that going to be applied? Because if I call somebody a racist, that's clearly a defamatory statement, but that leads right into the allegations in the complaint, the Title VII complaint. Same thing with sexual harassment. And if the ban on non-disparagement has a carve-out for defamatory statements, then you really open the door to the second phase of the litigation, where you are trying the same case, the same anti-discrimination case, but this time in the context of not sexual harassment in the workplace, but defamation. So that this whole McLaren-McComb really does create a large number of questions and problems for the practitioner and unintended consequences. The final thing I'd like to say is that social media really changes the game, because think of the mediations that we've had in which the plaintiff has larded the social media world with allegations against the company, against the former supervisor. What can you do about those? Because the social media, is forever. You can't take down many of the social media posts. So I've said enough, but food for thought.
Judge Legg, thank you. Judge Connelly, are there situations where you foresee a settlement value for an employer diminish if the employer can't require the employee to keep the allegations against the employer confidential?
Perhaps, but I think you also have to, in examining this, it might be helpful not to look at this from a lawyer's perspective, and maybe just from a layperson's perspective. And I think it's also important about timing when these decisions are being taken. In employment litigation, you're either going to get a case that you're mediating probably 2 years or so after the incident, if they've gone through the administrative process and then filed and done some discovery, or you're going to get it pre-suit, which happens pretty quickly, and that's done obviously to try to keep these allegations out of the PACER system and the other electronic systems. If you're at a case that's mature, that's been around for about 2 years, I think you have to look at, and I tell people this, you have to look at what has been the conduct of the plaintiff. Many of these people have kept things to themselves. They haven't said anything. And so the argument comes to the HR person or to the CEO. This person for the past 2 years has demonstrated that they're not going to say anything, and they haven't. So is it really important enough for you to do this? With reference to having, the corporate not say anything defamatory, that generally is not in their playbook. But even if it were, you can only really limit the corporate to maybe a handful of people, the people that are intimately connected with it, because you can't be responsible for the 3,000 employees. If you are at, pre-suit, the idea is to try to get, a case done quickly. And usually there's a premium that you put on that. In my experience, most people are willing to take the premium and, to sign off. Now, if that's not there, that's the protection that you're seeking, that may decrease the value of the agreement. The other thing is, one of the questions when I do my initial session with the plaintiffs, at the end, I usually ask them, what is your goal today? I'm not asking for a number. I'm asking, what do you want to happen today? And in 95% of the cases, people look at me and say, I want this over. It is the rare person that looks at me and says, I want my day in court. I want to be. They just want it over. They're tired. In some cases, it's embarrassing. They want to move on. And maybe we don't give that enough credence. And I can understand if you're the counsel for the corporation, when one of these things goes bad afterwards, you're going to bear the blame. But there is something to be said for the natural human view that there may be cases when we don't have to die. This is not the hill to die on. We may be able to trust people on this one.
Got it. Thank you. Let's take our first question from our audience, and I'd like to pose it to Jessica. It is from Andy Dansicker. Since employers generally are not required to provide severance agreements, won't this cause employers to potentially decide not to offer severance agreements? I would be concerned about raising this demand, as it might cause an employer to simply decide not to offer the settlement agreement. What do you think?
Thank you for that question. I think Janea pointed out that an employer wants to release claims. That is very much still always going to be the goal of an employer for several reasons. Bad PR, as Judge Connelly mentioned, not having a case in PACER, which is publicly filed. There are several reasons why severance agreements, in my opinion, will always be relevant and will always exist. Now, the form in which they will exist will, I think, inevitably change based on the evolutions that we're discussing today. But I do think that there are certainly going to be different considerations. There are going to be different requests that both sides are able to make. From a practical perspective, just looking at the defamation, the ability for an employee to say anything that they essentially want about a company, or their former employer, as long as it's non-defamatory. I think that gives it seemingly gives employees a lot of leeway that they did not have before the McLaren-McComb decision and the subsequent memo from General Counsel Abruzzo came out. However, in practice, I am very hesitant to tell an employee that they are now allowed to say whatever they want about a company, because I'm not a defamation attorney. So there is risk still for employees who sign agreements, because it can open the door to litigation if there ever is a comment that an employer does later see on social media that they find to be defamatory despite this particular provision. And so I do think that employees I still think employers will proffer severance agreements. I think that as Janea has pointed out, there is going to be immense scrutiny as to what those severance agreements now say. I think for employees, for attorneys representing employees, we do have more fodder for discussion. We need to be looking at these severance agreements very carefully, because the proffer of an unlawful agreement, I think that can lead to more negotiation. We now know what to look for, at least from this board's perspective, unless these cases are overturned. I think we really do have some low-hanging fruit to pick. And if the proffer of these severance agreements does include unlawful provisions, we can certainly go back to the company's counsel and say, hey, you have given my client an unlawful severance agreement. And so I don't think these are going anywhere. but I'd love to hear other perspectives as well.
Let's take our second question from Dad and Cosmo, again to you, Jessica. When settling a case for an employee who is no longer employed by the settling employer, I like to have a non-disparagement clause because the employee is looking for a new employer, and I don't want the former employer trashing my client. When I request a non-disparagement, I always offer it to be mutual. Is this no longer allowed?
Yeah, unfortunately, the mutuality of it is no longer allowed. So the employee cannot request that that the employer provide or require them, or they cannot consent to not disparaging the company. Now, if an employer gratuitously offers not to disparage the employee, that's never happened in my practice, where there's a unilateral promise by the employer not to disparage the departing employee. So, I mean, if anyone has had that experience, I'd love to hear about it, but that has never happened in my practice. I typically request a mutual non-disparagement agreement. That is not, I can't do that anymore based on the current landscape. And so I do, with the person who asked the question, I think that you and I are in similar shoes here, but mutual non-disparagement agreements or provisions are no longer going to pass muster, even if the employee is asking for that mutuality.
Jessica, thank you. Janea, let's turn back to you for a minute. The NLRB General Counsel's opinion opines that McLaren-McComb reaches beyond confidentiality and non-disclosure and non-disparagement, as Jessica has said, in severance and other agreements, to impact more provisions that might interfere with an employee's NLRA Section 7 rights. What impact do you think McLaren-McComb might have on the continued viability of non-compete clauses?
I think non-compete as a whole is just under fire generally. A lot of states are passing legislation and a lot of laws to really to outlaw the ability of the restraint on trade, on business, on seeking new business opportunities. And so anytime non-competes or a non-competition clause is going to be in an agreement, it's already going to have a lens go right to it. Again, it's very much looking at, well, what are you protecting, the reasonability of the provision. And a lot of times it's very industry specific. So for instance, a software or tech company has a lot more interest, sometimes sales, government contractors. They are a lot of times much more akin to protecting and also you see it in healthcare and medicine, looking at the geography, looking at the market for what they do. It's very much dependent upon size, reach, broad, duration, and scope. And so a lot of that is, I think, anytime it's being included in an agreement, the length of time, the distance, the nature of the agreement is going to be called into question immediately.
How about McLaren-McComb's impact on non-solicitation agreements?
So non-solicitation is also interesting because a lot of times it depends on the level of employee you're dealing with. Again, if you're looking at a managerial employee versus an employee who might just be, a rank and file, lower level in the organization, where going someplace else and saying, hey, you should come over to where I am, where they may not have any hiring authority or any decision-making authority, it might just be a referral in the system, is a lot different than somebody who is going to start up a whole nother shop and is leading an entire division, leading a department and saying, oh yeah, we're going to take you with, I want to take the whole team with me. Similarly, if you are in a sales environment, they are very conscientious about that as well, because it goes to business relationships that they have with their vendors as well. So of course, there is a need to protect the customer base, and that goes directly into the integration of the business. So an employer is going to still fight to the death to make sure that they can keep their customers even when people leave. So I don't think that those are going to go away. I think maybe the language will kind of be, might be tailored, might be changed a little bit, but I definitely think that they're still going to be there, and a lot of unanswered questions as to how they're going to fare in when it comes to enforcing.
How about McLaren-McComb's impact on provisions that require an employee to cooperate? in the employer's future workplace investigation or a government proceeding involving the employer?
I think they're very much going to be alive as far as the idea that, one, you have to, again, comply with your obligation with the law. So if you were called in an investigation with the EEOC, the SEC, there's nothing that an employer really can do to impinge on that requirement. Similarly, if you're subpoenaed, you have to comply with your subpoena. So generally, from a contracting perspective, you may or may not necessarily include a provision that is talking about, the duty to cooperate. It's more so I usually find it something that is, especially if you're leaving on considerable terms with the employee, a lot of times it's, you keep the last known contact information. And if you stay in touch with them, if you need them for something, you can call and you can work it out. So you oftentimes forward thinking and looking at drafting that may not be a top provision of a non-economic term that the parties may necessarily look to. There's usually others that they'll probably be more concerned about, again, like the non-disparagement, confidentiality. So I would say of the provisions, that may be one that you may not necessarily see so much agreement around.
Judge Connelly, do you have any thoughts about the general efficacy of provisions that require a former employee to both notify his former employer if he's contacted by the government and cooperate with the employer in preparing for a government, let's say, proceeding or testimony involving the employee?
I've had experience with that. Frequently, I get an agreement as to you will notify the former employee that you've been contacted. And if it's a request for documents or things of this nature, that you'll also tell them what it is. And I think you can justify that in the event the former employer wants to seek protection from the court, a protective order or something of this nature, at least gives them the opportunity to do that. With reference to the cooperation, I see it asked, and it really depends upon the atmosphere at the time of the separation and the time of the agreement, whether the individual is agreeable to, to helping out or not. And then sometimes there's also a request that, they be compensated on a typical hourly rate for whatever time that they spend doing this.
And your thoughts about, let's say, that kind of situation where the employer is paying the employee for the employee's time in cooperating with the employer. Any concerns there?
I think to be safe, I think I would encourage the person to at least tell the investigating agency that, this is what is being done, and to explain why. If the commitment of time is significant and the person has a family or other needs, perhaps it can be justified on those bases. But I think disclosure frequently is a pretty good proactive way to prevent problems going forward.
Janea, what impact might McLaren-Macomb have on the continued viability of liquidated damages provisions in settlement agreements?
What I see is I get people that ask for liquidated damages. I don't get very many people agreeing to them. If they agree to them, the amount that is usually agreed upon tends to be not that significant, $5,000 or $10,000. And I have had probably at least a dozen attorneys privately confide to me, I don't know why we asked for these. I don't think anybody has ever tried to enforce them. But maybe, the listeners here will have a different story. I just don't see it being a particularly large player in at least the cases that I work on.
Judge Connelly, thank you. Janea, what do you think? What do you think McLaren-Macomb's impact on the continued viability of liquidated damages provisions?
Yes, I think Judge Connelly hit it on the head with respect to enforcement. That is one of the biggest issues with a liquidated damages provision, because it's literally kind of like it can easily turn into a sub litigation of the litigation that you tried to get out of by entering the agreement. For example, you're monitoring the employee, you're making sure that they're maintaining that fidelity to the agreement. And if there is a breach, you usually have to contact them to say, we think you've breached. And then they'll say, no, I haven't. And then you'll say, well, cease and desist. And then they'll say, well, I didn't have anything to cease and desist, but sure. And then it's the continued while looking at the employee. And then if there is in fact a breach, then you have to, in order to enforce it, you're going to try to prove that there was in fact a breach. So to Judge Connelly's point, I agree. I don't see them as being a huge player because of the amount of work and continued effort that it is required to go forward with liquidated damages provisions. So I would say, again, in the sea of provisions and in the buckets that you have, that's a tool that is usually used in more rare circumstances and not something that is typically not something that you would, as a matter of course, try to include.
Let's talk about a different bucket, the no rehire, no reemployment clause. What impact do you see McLaren-Macomb having on these types of things?
I'm glad you brought that up because I actually wanted to make a point. I know we were talking about it. We were talking about the defamatory exception and the no rehire and kind of the ability to contract around that. So typically when an employee-employer relationship is ending, it's best for the parties to go their separate ways. And so oftentimes you will see a no rehire clause in a provision. I can see there being some pushback. I definitely have seen pushback before human rights agencies when the parties there's an agreement that has a no rehire clause, and they may, some HRAs have said that was considered retaliatory. So they didn't like the language at all, but they also did not necessarily prohibit the parties from entering into their own private agreement to agree to that. In light of McLaren-Macomb, I would say that probably goes more to in the restraint territory on Section 7 rights. So I would say you might run into a little bit of pushback there. But typically, I would say there's probably going to be more pushback now in light of the decision than maybe in prior years.
So Judge Connelly, when an employer insists on a no rehire clause in a settlement agreement, but the employee objects, how do you forge a compromise?
I should say, it is not in every case that they are asking for a no rehire provision. So when they do, there seems to be fairly strong feelings that this is something that they want. And I have to agree with Ms. Hawkins that, a settlement is an absolute divorce. People want to go their own ways. And you really begin to wonder, why do you want to come back and work for the group that you did not do well with? In all of my litigation, I have only seen this happen twice in 2 cases, and they were very large corporations where they could take the employee and put them in another geographical location, totally apart from where the circumstances occurred. But it's extremely rare to bring somebody back. I think that, this is something that one side or the other will usually break on. If somebody can demonstrate to me that there is a real reason not to have a no rehire, if you're in an industry that perhaps is highly concentrated. I once had a veterinarian, they wanted a no rehire, but she was working for a company that had something like 50% of the veterinarian clinics in the United States, which was a real restriction on her employment. And that was a good reason not to do it. It's something that it's an issue that's going to get decided at about 5:30 or 6 p.m. at night. Somebody's going to give on it.
Judge Legg, when an employer, let's talk about a different kind of back and forth. When an employer has been unwilling to provide an employee with a positive reference, you sometimes advocated to change the cause of termination to a no-fault termination. Why is that a potentially attractive option from your perspective?
Good. There are a couple of aspects to this. The first is that let's assume, for example, that you're applying for unemployment insurance or payments in the District of Columbia. If the the agency will contact the employer, the former employer, and if the former employer states that the former employee was terminated for, some dereliction, then the agency will not pay unemployment benefits. So that negotiating a statement that there was no wrongdoing that caused the termination is to the former employee's benefit. The second is that I think that the best way to handle the request for a positive reference is simply to have what now seems to be the norm in employment cases, and that is that both sides agree that any potential employer will be told that the former employee worked for the ABC company from X date to Y date in a certain position at a certain salary. And that seems to be the norm now. And I think that prospective employers don't hold it against the applicant that there was simply this what we would call a neutral reference. If an employer provides more, the former employer provides more, that former employer can open itself up to, for example, a lawsuit. So let's assume that the agreement is for a positive reference. The former employee was accused of sexual harassment or embezzlement or something of the like, and the former employer gives a positive reference. Yeah, this guy's a great guy and, wonderful employee. Then if it turns out that that employee has another problem with the new employer can sue the past employer for giving out false information. So I think that them being a little bit long-winded here, but I think the neutral reference seems to be the standard in the industry, and I think there are a lot of good reasons for it.
Judge Legg, thank you. Janea, if an employee wants one of the company's former managers to endorse the employee on LinkedIn and the manager is willing to do so, do you object?
I usually don't. We look at LinkedIn as its own separate thing because when you're speaking on LinkedIn, you're typically speaking in your personal capacity as you are on that platform. And we're more concerned about the statements that we are making as a company on behalf because we have responsibilities as a company employer. So typically a LinkedIn reference, if the manager agrees to it and wants to say this person was great at this, that, or to have you, that typically isn't our concern. Maybe we would consider it more so in the if a settlement context and the circumstances kind of said, oh, maybe we, would veer off. But typically we usually don't. We're not contracting around LinkedIn usually.
Janea, thank you. Jessica, I want to turn to you with one of our questions from Avi Kuman. The text from the NLRB GC's memo in the slide states that trade secret information for a period of time is fair grounds for a confidentiality provision. Is there any guidance on what period of time would be permissible for such a restriction?
So thank you so much, Avi, for your question. There is no guidance yet as to what a period of time would mean. I would look to the case law for restrictive covenants and the language surrounding what is a reasonable temporal restriction for a restrictive covenant. But still, that is subject to, that's case law. That's really going down a slippery slope. And there's really no clear guidance as to what a reasonable temporal limitation is for the maintenance of an agreement that protects trade secrets. So I think that this is a very ripe area for a court to weigh in on if there is that case that comes up. But right now, there is no guidance.
We have another question. I want to direct it to you, Jessica. This is about whether an employer in the wake of McLaren-McComb can keep the settlement amount confidential. What's your view of that?
I think that McLaren-McComb is very clear about, I don't think that the settlement amount is a trade secret or potentially proprietary. I mean, I think that when we get into wage transparency, I don't think it's an argument that settlement is a wage that you're entitled to. But when we get into the heart and the spirit of Section 7, it's about the terms and conditions of employment. And so I think that the amount of the severance agreement is certainly subjected to the spirit of McLaren-McComb, allowing for transparency in that number. And I don't think that employers are allowed under the text of that case to prohibit the disclosure of the amount.
The NLRB General Counsel has taken a dim view of an employer's use of savings clauses, Jessica, or disclaimers to cure an otherwise overbroad settlement agreement. In your view, can savings clause or disclaimers cure an agreement that violates the NLRB's holdings in McLaren-McComb?
So this is another area where I think that General Counsel Abruzzo's memo was clear in that savings clauses cannot cure an unlawful provision. And General Counsel Abruzzo was clear that the unlawful provisions will be severed from the agreement, but a savings clause in and of itself is not going to resurrect an unlawful provision. I do think they're a best practice to include in any employment document, but I do think that they in and of it themselves are not going to cure an unlawful provision.
McLaren-McComb, Jessica, allows an employer to restrict employee speech about the employer that is maliciously untrue, specifically employee speech made, quote, with knowledge or reckless disregard of its falsity. Do you foresee employers using this exact language in settlement agreements after McLaren-McComb?
I would say that the smart employer would. I will be looking from a plaintiff standpoint. When I look at severance agreements that are proffered to my clients, I'm going to be looking for that exact language because that's the most clarity that I have gleaned from General Counsel Abruzzo's memo. It seems like that is the language from defamation law. And it seems like that is going to be the only viable language for a non-disparagement provision, to maintain a non-disparagement provision in a severance agreement or in any employment agreement that has a non-disparagement provision. With that said, I do think there is still a risk for employees to go about making any statement about a company, as I mentioned earlier, because they're going to need to understand what this defamation standard means in its practical application. So to answer your question, I will be looking for that exact language because that seems to be something that the NLRB will be looking for as well.
Jessica, thank you. Judge Legg, let's talk about the situation where one party asks the other party's lawyer to sign the settlement agreement. When you get that kind of request, what's your response?
I've not had that come up actively in my cases, so I'm speaking theoretically. The attorney is the crafter of the documents and not a party to the active act of discrimination or the defense of wasn't involved in the discriminatory conduct. So that I would not require the attorney to sign the settlement agreement, thereby binding the attorney to the non-disparagement, non-disclosure, and the other terms in the settlement agreement. I would instead rely upon the bar rules barring attorneys from acting improperly. And if I were in private practice, I would be disinclined to sign.
We are ready. We are out of time, but we're ready for final thoughts from all of our panelists. And I would like to begin with you, Janea. Final thoughts for us.
My final thoughts here are the McLaren-McComb decision have really changed the decision, and the far-reaching likely results from the decision are definitely a challenge for both sides. It requires basically decades precedent, retooling and reviewing, really to make sure that decisions are not impinging upon employees' Section 7 rights of the NLRA. I think that one thing that has been clear, even through General Counsel Abruzzo's memo, is that there are still some areas with questions that we both have, and we're trying to figure out what is going to pass muster and what's not. So a lot remains to be seen. But in the spirit of the decision, we are looking at policies, employment agreements, anything that would be entered into between the employer and the employee to make sure that it is compliant with Section 7, which means giving up some things that we so held on to so dearly before, and being ready to anticipate more pushback from employees when it comes to agreements as well.
Janea, thank you. Jessica, final thoughts for us.
Well, first of all, thank you so much to my esteemed panelists. Thank you, everyone, for attending this discussion. I know that I have learned a lot from my panelists, and I really enjoyed sharing my insights. As much as our hands may be more limited in our discussions based on the practical application of McLaren-McComb, I do think that there are opportunities, especially for plaintiffs' counsel, to take away bright lines from the decisions that are coming out now. There are some clear bright lines that have come out of General Counsel Abruzzo's memo that I think that we really need to sink our teeth into. We also need to be very cognizant of the fact that these laws are evolving. There are cases, McLaren-McComb is up at, it's at the Sixth Circuit right now, so we need to keep our eyes on that decision, and we need to look at what the FTC is going to do next year regarding non-competes, because this conversation that we're having today could be very different a year from now. So this is just really an exciting time in the employment law arena. I'm very excited to be a part of it, and thank you again for attending today.
Jessica, thank you. Judge Legg, final thoughts.
When Abraham Lincoln was practicing law back in the 1840s, he was able to carry all of the law books that he needed when he rode circuit. This included one volume of the laws of the state of Illinois and Chitty's jurisprudence. And it's amazing to think how complicated the law has become, and becoming even more complicated by the day. We now see that McLaren-McComb has generated litigation that's up in the Fifth Circuit, that the parameters of McLaren-McComb are unknown and seem to be ever increasing, and that the FTC and the SEC have also jumped into the fray. So it's amazing how complicated the practice of law has become, but it's, in a sense, the Attorneys Full Employment Act, so it's not all bad.
Judge Legg, thank you. Judge Connelly, final thoughts.
I want to thank my fellow presenters. I felt the discussion was very helpful, and I learned a number of things. I want to thank the people that attended, and I intend to keep monitoring this over the next year, because there are changes that we'll all need to be aware of.
Judge Connelly, thank you. Ashley.
Thank you again for having us and for the delightful discussion. I think this actually underscores why we need organizations like MWELA, to discuss how complicated, as Judge Legg said, the law has become, and to keep us abreast of the changes.
Ashley, thank you. And Yona, we need the College of Labor and Employment Lawyers as well, and we need the college's final thoughts. What do you got for us?
I don't really have final thoughts so much as I was just going to sort of add a footnote to what Jessica said, the questions about the amount, whether the amount can be kept confidential. And I would just say that there is an argument. If you look at General Counsel Abruzzo's memo that gives further description with respect to how McLaren is going to be applied and her views, she references OM 0727, which is an operations memo that's been in effect since 2002. It's the way the NLRB looks at non-board settlements when somebody has filed, say, for example, a lawsuit and an NLRB charge, and they want to resolve the NLRB charge with a non-board setting. What can be in the settlement agreement that would preclude it from being approved? And one of the things that they say in that memo says is that despite confidentiality clauses causing problems, that having a confidentiality simply as to the amount of the settlement is appropriate. So I think there is an argument to be made that, because if you go back to the focus of what McComb stands for, it's trying to protect employees' rights to engage in protected concerted activity, and that would be wages, hours, and working conditions, and things that they might want to say that would help other employees jointly join to try to improve their wages, hours, and working conditions. And I'm not sure that a settlement amount or a severance amount falls into that category. So I think there is an argument on that issue. But I would say, as my final point, as a former practitioner in Jessica's kind of practice, I never had a client who disclosed the amount. The amounts always come out from management. It's because somebody leaves a check on the copier or somebody says something to someone else. So I just raise the question about what is really the importance of these confidentiality provisions. Thanks
Yona,
for all your time.
Thank you. All right. I want to thank all of our presenters. Thanks to Janea Hawkins and Judges Benson, Legg, and William Connelly for participating in today's program. A special thanks to Jessica Childress, who organized this webinar for us. And a thank you to Yona Rozen and Ashley Bosché, and our co-sponsors for today's program, the College of Labor and Employment Lawyers and the Maryland Employment Lawyers Association. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's next webinar on December 7th at 12 o'clock, How to Avoid and Resolve Trade Secret Claims Against Employees, featuring U.S. District Judge for the District of Maryland, Stephanie Gallagher, and Max Miller from the Federal Trade Commission. So we'll hear from him about the new rule and what the Federal Trade Commission is doing in this space. For all of our programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.